Thank you very much. Good morning, everyone. Welcome to your first breakout session of the NACM conference. Hopefully I won't disappoint you with this, but hope you enjoyed this morning's session and have enjoyed the conference so far. As a former president, I love this organization very much, and I hope you will enjoy your time here networking and getting a lot of good educational sessions. And just so you know, our session's being live streamed today, so welcome to everyone who's watching online or who will be watching later. So this is something that NACM's able to do to extend the ability for our colleagues across the country to get education as well, who might not be able to attend in person. So let me just start by asking a question, which I probably know the answer to, but how many of you find that mental health issues are prevalent in your court system? Probably not a single person in the room who is not raising their hand right now. And it seems like more and more today, this is an issue that we're dealing with, seems to be a growing problem in the courts. And so this is an issue that we're all having to struggle with and how to handle it and how to deal with it. How many of you would say that you have plenty of resources to deal with those issues in your court? Yeah, no hands. That's what I expected there as well. So that's one of the challenges that we face in the court system is we have the problem of individuals with mental health coming into our courts for various reasons, and the other problem is very little resources and very little ways to deal with them. This was a problem that the Conference of State Court Administrators found to be one of the most pressing issues that are facing us. And just for all of you that may not be aware, the Conference of State Court Administrators has been around for over 50 years. It's made up of the state court administrator for each state and all of the territories of the country. And basically what happens is those 56 members get together every year for a couple of times in person, once in the summer and once in December, to meet and talk about issues. But then we also, similar to NACM, have a number of committees who meet throughout the year and discuss various issues. One of those committees that exists is what's called the COSCA Policy Committee. And basically what the Policy Committee's responsibility is to write a white paper every year to talk us and focus on an issue. The first of those papers was written in 1999, and it was sort of a new frontier for COSCA at the time. And they wrote on the subject of problem-solving courts. And if you might recall, in 1999, problem-solving courts were just beginning to take hold across the country, and there weren't very many of them. And there was question at the time about, well, should we really even be doing this? And so what the conference spoke to is the importance of the courts embracing them and laid out some principles around those areas. And every year since then, COSCA has published one of these policy papers on a topic. Some of them have been very controversial, some of them not so much. There was a paper written a few years ago on digital recording. You might know that one was very controversial, and there was a lot of discussion amongst the national community about that one. But then there have been other ones. We've written one recently on fines, fees, and court collections, obviously a real hot topic. That was written actually several years ago, and the topic of it was that courts should not be revenue centers. And oddly enough, a few years later, that became a centerpiece of the debate about how to handle the issue of fines and fees. So we feel that these papers are really important. We feel like we try to set out a policy area that can be important, and thankfully, NACM has been great enough over the last several years to invite someone from COSCA to come and present on the policy paper at the annual conference. So that's what this session's about today. Just to give you a little insight and a little heads up, the paper that's being written right now, and it's written by, I should say, it's written by the state court administrators themselves. So it's usually a collaborative process. Sometimes one author will take a lead role, which is what I'll talk about in this paper. This year it's being written by a number of state court administrators collaboratively across the country. We are ably staffed by a member of the National Center for State Courts. In previous years that has been Richard Schaffler, and in this year going forward it's Nicole Waters, who's actually in the room, so she can grade me after I'm done as to how good of a job I did or not. The National Center is obviously very helpful to us in this process of helping us collect the best research out there and also make sure that our papers are well written. So Without sort of further ado on this, we'll jump into the COSCA paper this year. That was actually, it's always adopted in December, so I'll say this year probably over and over again, but obviously it was last year. So the paper this year really focuses on what should we do and what are the reasons why we've gotten to this place with regard to so many individuals in our criminal justice system who have mental health issues and mental illnesses. And what do we do about it? And what are some of the policy suggestions that we have for both the courts and for legislators and others as to how to handle this problem? Let's just talk about a little bit about the problem here, about how we got to where we're at, what the problem is, and just kind of give you some statistics, none of which will be shocking to any of you in this room who deal with these issues on a regular basis, but something that's sort of, obviously when we're writing this to the world, is important to make sure everyone understands the extent of the problem we're facing. So what we all know is that individuals generally who have serious mental illnesses who come into our system oftentimes languish in jails for long periods of time. In fact, what we now know is that jails and prisons make up the largest psychiatric facilities in 44 states. How many of you would say that's about where it is in your state? So we oftentimes say, many times we use the statement that we now have the de facto psychiatric facilities that are run as jails, and that judges involved with that process are having to help manage that issue as would it be. So one of the things is that there are now 2 million individuals who have mental health illnesses every year. 383,000 of those individuals are in jails, of some of those, and versus 40,000 in hospitals, where perhaps they may belong. Certainly that'd be a better alternative than jails. Maybe they could be served through outpatient, which we'll be talking about, but most of those, obviously, a significant number, almost 10 times the number of people in hospitals are in jails every year. What we also know is that just from the research itself, that jails are not an appropriate psychiatric treatment facility. So when we're trying to deal with these psychiatric issues, most of our jails, there are some that are exceptions to this, most of our jails are not places where individuals can receive appropriate psychiatric treatment. So we've got all these individuals that have serious mental health issues. They're in the jails because that's de facto where they're going right now, and then we can't really even treat them effectively. And many times individuals who are in the jails are actually getting worse. We're actually many times causing them to decompensate even more because of the place where they are and the fact that that environment is not appropriate for them. Goes along with the fact that there's rarely appropriate medication for them. I know in my own state of Texas this is a big issue because individuals who are on psychotropic medication in the community, when they get arrested in our state, the jails and local jurisdictions are able to decide what's on their local jail formularies for medication. And they oftentimes don't like to pay for the expensive drugs because whenever they're, as you all know, when they're in jail, no longer do their federal benefits cover the cost of their, at least in my state, don't cover the cost of their medication. So the local communities are on the hook for the medication, and many times they don't want to pay for the more expensive psychotropic drugs. So you might have an individual who maybe is able to be stabilized in the community on certain drugs, and when they come into jail, all of a sudden we change their drugs. A wonderful, or not, experience for them where all of a sudden we can cause them to no longer be stabilized in jail. So obviously it's a pretty significant issue for us. What we also know is that these same individuals are oftentimes rotating in and out of our system, our criminal justice system. Some of the most frequent flyers in our criminal justice system are individuals who have mental health issues, not because they're causing major criminal justice, major felonies and major issues. It's many times because of the minor offenses that they're arrested for. Obviously there are exceptions to that, but generally it's not for major offenses, it's generally for those smaller offenses. And what we know about individuals with mental health issues is that between 25 and 40% estimates kind of change, but between 25 and 40% of the individuals with mental health issues has spent at least some time in jail. And so that's what we see happening. What we also know, and you all raised your hands verifying this a second ago, is that in most of our communities, there is a lack of community resources to really deal with these individuals on an appropriate basis. And so what we see happening is, of course, they're destabilized in the community. There aren't resources to deal with that, and they get arrested, and then they come into jail. And we don't have the facilities, so it's just this vicious cycle that continues. As was mentioned a second ago, and as you all verified, most of our courts lack the resources to really order individuals with mental health concerns to go obtain because they aren't available. So if a judge says, well, I know what would help with this situation is for this individual to receive mental health services, I'm going to order you to blank. And most of the time judges don't know what to fill in that blank because the resources are not widely available. What we also know is there's a fiscal cost to this. So, depending on where individuals are on this issue, different things speak to them. But one of the things that's an issue is it is definitely a problem from a fiscal perspective. What we do know about individuals with mental health issues is that they are the most expensive individuals to incarcerate because of all the various needs that they have. In fact, the numbers show that it's about $35,000 a year to have someone in prison that does not have a mental health issue versus $95,000 per prisoner per year for them to be incarcerated if they do have those issues. So obviously almost 3 times as much to incarcerate them. So huge problem, big numbers. This doesn't even talk about just the social impact of this and just sort of just thinking about the services and how this is impacting them directly. But from the numbers, you can see it's a big problem that we're addressing. So the question is, how did we get here? Is this just sort of a gradual over time issue? All of a sudden, do we have more mental health issues? What caused us to get here? And so we looked back at the history of this, and I wasn't aware of this, so maybe you aren't either. It's kind of interesting to me how this all happened. But prior to the 1960s, there were a lot of people who had mental health issues, some who didn't have mental health issues, who were being committed to mental health facilities. So there's stories about husbands getting their wives committed and wives getting their husbands committed. Usually it was the husbands getting their wives committed in the 60s because of what I would call somewhat bogus or completely bogus reasons. And so a lot of our facilities were filled with both legitimate and illegitimate mental health issues. And so there was this big outcry from the public about, my goodness, we have all these people locked up in these facilities, some of whom don't need to be there. There were these stories about all these issues going on. And so the public outcry was, we have to let these people out of the state health, these mental health facilities, and there surely is a better way of dealing with any of the ones who do have mental health issues in the community. And so Congress said, that makes sense to us. And so they passed the Community Mental Health Act of 1963, and rather than requiring or passing a law that said states could no longer include to lock people up in mental health facilities, they did as the federal government often does, and they instead created incentives for the states to do so, or maybe big sticks on the end of federal funding that really began to change the behavior. And what the Mental Health Act of 1963 did was Congress prohibited the use of federal funds on institutionalization. So any of the mental health money that your state was receiving could no longer be used on institutionalization. So of course, many states at the time were using federal funding to do this. So when the federal government says you can no longer use it for that, you can imagine what happens. All of a sudden, we say, well, we shouldn't be locking these people up. The promise was that instead, there would be funding provided to make sure that these mental health services would be made available in the community. So we would stop putting them in facilities. We would have more community health services made available. And of course, what we know is that those community mental health services never came. So that promise never was fulfilled. Many times that happens. The other thing that happened was there was a U.S. Supreme Court case that was decided in 1975, O'Connor versus Donaldson. And what the case said was that if someone could be safely placed in the community, then they could not be hospitalized. So if there was any alternative, then they couldn't be placed in the hospital. So obviously for individuals who were not able to be placed safely in the community, hospitalization was still allowed under the U.S. Supreme Court precedent. But if they could be placed in the community, then that's the direction we should go. So obviously that case in itself changed even the law. So it was no longer just the federal incentives. Now there was law as well. So what we saw is that most states then began to severely limit the court's ability to order involuntary inpatient commitments. So we saw a huge decline in the hospitalizations. The facility populations declined significantly, and individuals who had perhaps legitimate mental health issues were now being placed into the community with the promise of receiving these community mental health services, which weren't available. So that's how we got to where we're at today. Obviously, that's causing our significant issues that we face. So a couple of other things were replaced with as far as how to get someone involuntary treatment. This is, inpatient, outpatient, whatever it is. Most states replace their involuntary commitment standards with a couple of these standards. One is that the person had to be shown to be dangerous. So you might have heard this issue of danger to self or others. That's generally what the terminology is in most states' statutes with regard to this. And that's the most prevalent one today in statutes, is that the individual who's seeking for that person to be involuntary committed has to prove that the individual is a danger to themselves or others. Another standard was put in some states, which was that someone had to be gravely disabled. So the definitions differ a little bit from state to state, but generally a comment around just being that their mental health issues have caused them to be gravely disabled. And then the last one is that there be a need for treatment. So there are some states that have in their law provision that the defender or the individual has a need for treatment. So that's another standard that can be employed in the states. Not all the states are the same. In fact, most of us are not the same. Our statutes differ. Most of them have the danger of self or other language pretty consistently, but the other two, it just sort of differs from place to place. What is interesting about all these is that all of them require that there be some substantial risk of danger to self or others in the future. So if you think about this, what we're asking judges to predict with whenever they get the evidence, or for the parties to present to the judge, is a prediction of future risk, which of course is a harder standard to meet. And so it's not really looking at what is the situation with the individual today, or look at the situation over the past weeks or months. Instead, we're looking at predicting future risk, which is significantly higher. What we also know is that some states limit who can even file these applications for involuntary commitment. And sometimes it's limited just to professionals or law enforcement. So if family members are experiencing an individual around them, family members or friends, who they believe needs mental health services involuntarily provided to them, many states don't allow them to seek that. They've instead got to either go to law enforcement or some other professional. What some people have used as a criticism for this is, of course, I've used it myself. People call me and say, what do I do with my son who has these mental health issues? How many of you have given the same answer I have, which is, well, get him arrested. And that's a sick thing to say, but many times that's really the best, honestly, it's the best thing that people can do based upon the way our system works now, which is somewhat of a sad situation for those family members and not really good advice to be able to have to give people, but that's oftentimes really the only recourse individuals have. The other thing that's a barrier that sometimes causes issues for people trying to get individuals this type of treatment that they need is that many states require the participation of multiple physicians. So once again, trying to get all these physicians together to coordinate their evaluation and get that all done can sometimes be a barrier. In my own state of Texas, we do allow family members and friends to file applications for involuntary commitment, but it's not allowed to be filed unless the person has a certificate of medical examination filed with it. So if I were to want to go get my son involuntarily committed for mental health services, I have to get him to the doctor to be evaluated before I can file the application. Obviously a huge barrier when you're dealing with someone who may not understand that they have a mental health issue that needs to be addressed. So a lot of these barriers exist out there, which many times limit the ability for individuals to get mental health treatment unless they're in the criminal justice system, in which case many times it becomes a forced treatment, and many times that occurs in jail because those services aren't available in the community. So really that's the situation we're dealing with today. I'll stop here and just say, is there anyone who has any questions? Or at this point, we're going to give some time at the end for discussion, but I just don't want to run past this because I think it's really important. Okay, we'll move on. We'll have some time at the end. So another thing that's a big issue, a big point of this paper that you should be aware of is the sequential intercept model. How many of you have heard of the sequential intercept model before? So basically what the sequential intercept model looks at, it's been developed by a number of groups and been widely published in the mental health area, but what it looks at is what are the intercepts at which the criminal justice or even the justice system generally intercepts with individuals with mental health issues. And the attempt is to try to identify what those are and what are the things we could do at each one along the way. And so, for example, intercept 1 is contact with law enforcement. So generally, that's where the first contact with individuals with mental health issues is whenever they come into contact with law enforcement. And so the recommendation there, of course, is we should make sure our law enforcement are well trained in how to deal with individuals who have mental health or in mental health crises at the time they interact with them. So, for instance, crisis intervention training is one of the recommendations that the COSCA policy paper really advocates for, because we've seen in communities where that's been done a significant difference, because rather than a law enforcement officer taking that individual to jail, many times when they have crisis intervention training, they can instead take them to a mental health facility or get them somewhere to services that are more appropriate than the jail. So that's one thing that's recommended. A second one is intercept 2, which is really the initial detention and court hearing. So when they're first arrested and they come into the court system, we have this where the judge is interacting with them, that's an opportunity from our perspective for intervention to occur. And the COSCA policy paper really speaks to advocating for screening and assessment up front to make sure that judges are aware at this initial hearing that the individual has a mental health issue. As you all probably know, many times that does not occur, and so judges who are interacting with these individuals for the first time in court don't even know the individual they're dealing with has a mental health issue. So screening and assessment is key. Another one that is recommended in the paper is the idea of pretrial diversion. So considering are there places these individuals could go versus more further deeply into the criminal justice system. So we'll talk a little bit a second about some of these things, but there might be pretrial diversions to just divert them out of the system so that rather than filing charges, that they be other ways of dealing with them. And then, of course, there's a recommendation that the courts be able to provide adequate service linkage. So could we make sure that we are able to link them to mental health services in the community right up front? Intercept 3 is after incarceration, and this would include things such as mental health court and other services. And of course, the big recommendation here from COSCA is linking individuals up with mental health courts or other types of problem-solving courts that might be appropriate for them, but the one specifically addressed here is mental health courts. So as you know, obviously we have, COSCA has as I mentioned earlier, in 1999 advocated for the use of problem-solving courts. Again, recently in the last few years, also advocated again for the use of problem-solving courts, mental health courts being one of those. And as you probably also know, that mental health courts are not as widespread as other types of problem-solving courts. And so the recommendation here from COSCA is let's expand them and use them as appropriate with individuals as we can. Intercept 4 is reentry. So once the individuals come out of incarceration, the recommendation here is that we need to do a better job as a system. Obviously, this may not be court-directed in every jurisdiction. We as a system need to do a better job of reentry planning and making sure that those individuals have services as they come out of incarceration and that there's coordination of that care so that we're not just saying goodbye, good luck, and there's no linkage. Because as you probably know, many individuals who come into jails, their benefits, federal benefits, are suspended, their medications suspended, or terminated actually in many jurisdictions, and they have to go apply to get back on those benefits when they come out of jail. Even if it's a short stint in jail, that can occur. And of course, when you're dealing with someone who has mental health issues, they leave jail, their medication stops, and now we're asking them to go and do all these applications and things. Obviously, there can be issues that arise there. So the goal there is to try to make sure that there is this coordination of care and that there is no the cessation of these types of services that we're providing to them. Many states have begun to, and local jurisdictions have begun to, instead of terminating their benefits, suspend them while in jail, and then the jail actually coordinate getting them re-linked up and their benefits turned back on as they walk out of the jail, so that there's no cessation of those services available to them. It's a really important issue, I think, for us to consider. Intercept 5 is parole and probation. And so obviously the goal there is making sure that they're being provided the appropriate services while they're on parole or while they're on probation. So screening for what are the appropriate services, planning for those, and once again, that coordination of care between what the system is providing versus what's available in the community, and making sure there's a good transition between those. So those are the current 1, 2, 3, 4, 5, which have been the traditional intercepts that have been advocated for. COSCA is not the first to call for Intercept 0, but we stress the importance of what we call Intercept 0, which is why should we wait until there's contact with law enforcement to get involved with individuals who have mental health issues? So I mentioned my story earlier where I say someone calls me and the answer is, well, contact with law enforcement. There should be a way for us to deal with individuals who have mental health issues prior to that. So we urge Intercept 0, which is that prior to contact with law enforcement. And in particular, the point here is that the civil justice system be able to identify earlier in the process and to ensure that these individuals get treatment. So we'll talk about how we would do that in a second, but that's the goal, is let's not wait until they're in the criminal justice system to deal with their issues. Let's try to deal with it up front through some other mechanism. Any questions on Intercept? We have one in the back, so Kevin has a question. Let's, just so you know, since we're being live streamed, I'm going to need you to wait till you get the microphone, just so our colleagues who are watching online can hear the question and the answer. So, Kevin.
David, as you're going through these sequential steps, I was wondering if COSCA talked at all about whether this was only adult-focused and whether these intercepts would be the same in the juvenile system, or are there any differences in dealing with kids that we have coming in through the system? So that's one question. The other one, I was curious of, after looking at this and knowing that healthcare benefits get cut off when folks are going into jail or juvenile detention, and then there can be delays when they're coming out, is COSCA looking at any advocacy work to try to get that law changed?
Good questions. My recollection from the paper, and Nicole, you can help me if I go astray here, is that there's no differentiation in our paper between adults or juveniles. We're basically just saying this applies to everyone. So there's no specific reference to juveniles, but the principles would apply equally to there. Obviously, we might change some of the terms just because of the juvenile terms, but the principle is the same way. And really what the point of this discussion is that all of us in local jurisdictions, state jurisdictions, all of us should be thinking about where are these intercepts, who's involved, and what are we doing at each one of these steps. That it should be an intentional look at how do we go about addressing and making sure that at each one of these times when there's an intercept with an individual, are there ways that we can deal with them in a way so that we don't get them down to intercept 4 or 5, to try to get them services in a way that gets them from going deeper into the system. So including Intercept 0, which we'll talk about more in a second. With regard to the recommendations about getting laws changed, I'll ask you to hold that one for a second because we do have the whole set of recommendations coming, which will address some of that you've just talked about. All right, so of course Intercept 0 sounds great, but there are obviously sometimes barriers to these things. And a couple of those the policy paper talks about, which is this idea of the standards that we have right now in most of our states' laws with how to intervene earlier. And what most of our states currently have is this idea of this future conduct-based standard. I mentioned earlier this idea that we have to predict what is their future conduct going to be before we can order involuntary services for individuals. And so the push for us is that we should have a capacity-based standard in our states that we can consider. So how many of you are familiar with the guardianship system in your jurisdiction or your state? So many years ago, guardianship was also on this future conduct-based standard. So in order for someone to be placed under guardianship, you may call it conservatorship in your state. for someone to be placed under guardianship or conservatorship, there had to be this proof that there was a future dangerousness or future conduct issue. And of course, that has changed in every state to a capacity state. What is their current capacity? Their mental capacity or incapacity, as it's in most of our states. The key for us is we've got this barrier where right now it's hard to provide early services because we have this issue of predicting future dangerousness, which is a higher standard. And so, when we can look at an individual and say they don't currently have the capacity to consent to treatment, and so therefore and they need treatment, we should be able to order them. That's a problem in most of our states' laws currently. What we know, of course, is that early intervention is really key. If we don't have early intervention, things spiral out of control, and many times the situation gets worse. There may be more serious offenses committed by individuals. So the key is to try to get this early intervention with individuals. The other thing I mentioned, when we're looking at the capacity-based standard, we're obviously looking at what is their current condition and their current ability to consent to treatment. So that's the key there. We have seen some states begin to make this transition. So there have been a few. Michigan's one. So Kevin, who asked the question a second ago, they've been one of the leaders recently. New York, a few other states have begun to make this transition, but it is somewhat limited still across the country. So COSCA's recommendation here is that when a person's judgment is so impaired that they can't make informed consent to treatment, that the courts ought to be able to do that based upon their current capacity to make that decision. So that's really one of the main recommendations from the paper, and we'll spend some time talking about that. One of the ways that this is being done is through this provision of what's being called assisted outpatient treatment, or AOT. You may have heard about this. I had not heard about this before we started looking at this issue. New York was the first to really begin to utilize this idea of AOT, assisted outpatient treatment. And basically what it is, it's court-supervised treatment in the community, or outpatient commitment. Sort of an odd word that some jurisdictions use, but outpatient commitment. So the idea is that the judge can order them to go and receive treatment under a mandate from the court in the community. In AOT, the key is to have a really highly individualized treatment plan. Those of you that work around problem-solving courts, some of these concepts will sound very familiar, since that's really what we've worked towards in that area and have found to be very effective. And usually these types of services are not only case management, personal therapy, medication, and really any other services that are designed to promote recovery, along with the treatment services, mental health treatment services that are available. What generally occurs in AOT is if someone is non-compliant with this outpatient commitment or AOT, they're then able to be ordered into inpatient or hospitalization based upon their non-compliance with treatment. So that's how that works. It is generally, AOT, let's just be clear, is not confinement. A lot of people, when they look at assisted outpatient treatment, they forget the word outpatient in the middle. We're not confining them in a facility. As part of this, the goal is to keep them in the community receiving these services on an outpatient. What we know is many times the best place to use this and employ it is right before a mental health crisis. So the goal is to try to catch them early as they're about to go into crisis, try to get them into this outpatient treatment, and hopefully avert the issue with the mental health crisis. What's been shown, the research shows that it reduces hospitalization. It also reduces arrests, incarceration, reduces poverty, homelessness, and overall cost. So New York's example has been proven to be very effective. I will say there is debate about this, but I think for the most part the research shows it's been pretty effective in these areas. What we do know is that there are some upfront costs to AOT. You can think of them probably if you're thinking about your local jurisdiction and how you might begin to implement these issues. But in the long run, there's an overall savings. What the primary cost up front is, those mental health services that are available in the community. I'll give you an example from my own state of Texas. So we actually have some barriers, which I won't go into today. I'll talk about it in my next session on this issue. But we have the ability right now to do something like this in Texas. And since we collect the statistics at our office about how often this is used, I got to looking at this issue and seeing, well, how often are people being ordered into outpatient commitment? And about 98 to 99% of all of our involuntary commitments are to inpatient. So you can imagine that's the most expensive bed in our state to send someone is to an inpatient commitment. And so I started asking some of the judges who do this work, well, why are you ordering all these people into inpatient, and is that the most appropriate place? And the first answer is the reason why they're ordering them there is because there's no other place to order them. And number two, yes, they could be ordered into outpatient just as effectively if we had the resources to do it. And so, which is sort of interesting because remember the U.S. Supreme Court case that says you can't send someone to the hospitalization if they are able to be treated in the community? But there are no resources to treat them in the community, so there's no way to say they are safely able to be treated in the community. So my argument to my own state is if we reinvested some of these dollars that we're spending on inpatient commitments into the community treatment, we could actually save money perhaps for the state overall. But that obviously takes some upfront cost to actually make that happen. So something to just keep in mind as you look at this issue. So a couple of things that the COSCA paper advocates for is, these are really ultimately the recommendations. And the first thing is some people, even amongst our colleagues, said, well, why are we writing about this? This is not really our issue. This is really a community health issue. It's a legislature issue. It's a funding issue. So this is not really a court issue. And ultimately where COSCA came down on this is really it is our obligation as court leaders to really think about how we can make sure that the system works as effectively as possible. And at the end of the day, it's affecting all of our courts, either through judges who are trying to order civil commitments who can't because there aren't resources, or the fact that individuals within the community are not getting the services they need and ending up in the criminal justice system where it's now a huge issue for all of us across the state. And so one of the first things that COSCA recommends is that really judges and court leaders should be the conveners of this conversation. That all of us in our local jurisdictions or at the state level should really sit down with, and the key I will tell you, even though this is a COSCA state leadership paper, the key of the recommendation is this is a local issue that all of our local judges and local court leaders should be having this conversation. So the recommendation is bring together all the players that are affected by the system and begin to talk about the INTERCEPT and where are we as far as the intercepts along the way. What are we doing at each intercept? What are those intercepts? Who's involved? And begin to come up with a plan with that. To begin to think about what are the community resources that are out there. One of the things that we've found in our own state is that many times judges don't even know about the resources that are available. So doing this idea of community mapping about what resources are available to judges, and then where are the holes, and are there ways to fill those holes in a way that is effective. So the first recommendation, probably one of the key recommendations for you all to think about is really this idea of convening, beginning to have this conversation at the local level. The second one is that court leaders should really urge the policymakers to change the legal standard from this idea of conduct-based standards for commitment to capacity-based. So in many of our states that will require legislative changes, which is obviously something we don't control directly, but one of the keys here is really beginning to educate our legislators about the problem we have. We've had conversations in Texas about this. One of our legislators who was in the room when we talked about this said, well, this makes no sense. Why would we make people get arrested before we are able to give them treatment? So once you start having the conversation, they begin to understand the situation. Obviously, the thing I would say in this is you've got to make sure you have the right balance in the room when you're having these type of conversations, because we can go the other way back toward the 1960s and be committing everyone to either inpatient or outpatient. So just making sure there's a good balance of groups in the room to have this conversation is important, and making sure you strike the right standard. The really good thing is obviously there are a few states who are models for us and how to have the language that's effective on this, but the key here is to really begin to think about changing that legal standard. The third recommendation from COSCA is to expand the use of AOT, or assisted outpatient treatment. The goal is to try to keep individuals who are currently, and probably in your state and mine, going into inpatient commitments for mental health services, to try to figure out how to get them into outpatient where that's appropriate. Obviously, that includes the idea of ensuring that there are plenty of services for them in the community, which we understand is a barrier right now, but pushing towards that, trying to figure out how to best utilize those services for them in the community so that we once again keep them from going into the criminal justice system, and trying to use that as a model. I know in our own state, we're actually looking at a proposal right now that would allow individuals to be diverted out of the criminal justice system into AOT. So it's crossing the civil criminal line, especially when those individuals have competency issues. So we're looking at that issue, and we think there's some good support behind that idea as well. Once again, we would urge that everyone really take a look at the sequential intercept model and support adopting that, and talking about all the individuals that are involved in your system to try to figure out how they can play a role in that. And then lastly, the key recommendation here is to really think about providing information to the policymakers to show the savings from the addition of mental health services. So a lot of times when we're talking with whether it's local funding authorities or state funding authorities, all they're seeing are the dollar signs as to how much is this going to cost. And if we can really begin to talk to them about what the cost savings would be if they were to be able to provide these services in the community. I know the court administrator from Harris County is in here, from Houston. They have one of the largest populations of individuals with mental health issues in the country, and I see the court administrator from Chicago here, and I know they have the largest facility with most mental health issues in the country. So, just think about if some of the, even 25% of those individuals were able to be served in the community versus in jails, the savings to the community would be enormous. And of course, the benefits to the individuals would be enormous as well. So beginning to have these conversations with our policymakers about thinking about how to do this differently would be an interesting thing. And this was not in the paper, and it's not on my slides, and I wasn't going to talk about it, but as I talk about this, it makes me think about, we also need to start thinking about, I don't know how many of you are familiar with this idea of social impact bonds, but there are a lot of private organizations willing to invest money in upfront costs primarily to see long-term benefits. It's kind of a weird thing. It's an investment. It's basically they're taking a risk, and their return is they want some of this. They want to be paid back with the savings that occur with some interest on it. And maybe it's something worth thinking about if your local community, your local funders aren't able to provide this upfront cost. Thinking about partnering with one of these organizations to be able to assist with those costs. Overall, it would be a savings, and perhaps they would get their funding back. So those are some of the recommendations. So that's basically the COSCA policy paper. You have a copy of this. The paper is actually posted on the app, so you can go read the whole paper for yourself. I've tried to summarize it. Obviously, there's a lot more in the paper. So what I wanted to do now was maybe just, with all of you in the room, perhaps we could all benefit from each other learning about what's working in your jurisdiction. So first of all, let me, just ask, are there any questions before we jump into that? Any questions or comments? Once again, just wait for the mic, and then we'll continue.
Well, thanks so much. It's great information. The one thing I found missing from this, and maybe you discuss it in the paper, but it's not so clean that someone just comes into the court system with the mental health issue, but there's so much comorbidity between people who have chemical dependency issues and mental health issues, and I'm wondering if you have any recommendations, you talk about that in the paper at all. So that's one thing. And I'm also wondering, the second thing, with the AOTs, I could see judges perhaps being a little hesitant to go with the outpatient model for maybe the fear of someone committing a crime while in one of those who was not committed. So I'm just wondering if you have any recommendations, perhaps maybe push past some of that potential resistance that might come with keeping someone in the community when there might be worry that they commit a crime that then would, reflect negatively in the press on someone.
Yeah, great questions, and certainly legitimate issues, both of them. With regard to the, I can't remember if it actually made the paper or not. But with regard to the issue of the comorbidity issues, where we've got these co-occurring disorders of both substance abuse and mental health, there was a lot of discussion around the fact that what we know is, what the research shows us is occurring is that they're using substance abuse to try to deal with their mental health issue. And that the key is to try to deal with their mental health issue that will then hopefully, and we're obviously with some drug treatment, alcohol treatment involvement to deal with substance abuse. But if we can deal with the root issue, which is their mental health issue, perhaps we can address that. So, I mean, at the end of the day, the mental health services we feel are the key to that. Because even if we deal with the alcohol and drug issue and we get them clean, and we don't deal with the mental health issue, they're probably going to be back on drugs and alcohol at some point in the future, because once their mental health crisis, once they get back in crisis again, they're going to want to self-medicate to deal with that. So the key there was really to try to make sure that we're dealing with their mental health issues in some way. With regard to the issue of judges being nervous about placing individuals in the community, it's completely a legitimate question. It's the same question we're having with judges about letting people out on personal bond instead of forcing them to pay a monetary bond to get out of jail. Judges have a concern about making sure that's available. I think a couple of things are key to dealing with that concern. One is making sure that appropriate services are available in the community. Because if I'm a judge and I'm on the bench and I say, well, this person should be treated in the community, but the services are not available, I'm very hesitant to do that, because I'm afraid they're going to get out and decompensate again and destabilize and all of that. The other thing I think that's really important, and there is a recommendation in the paper that I should have spoke to this, is education and training. So I think there's this impression amongst all of us, maybe some of you in the room aren't like this, but all of us, including judges, that individuals with mental health concerns are dangerous. And that's just not the facts. Yes, some people with mental health issues commit horrible crimes, but so do people that don't have mental health issues. And what we know, the facts are, is that most people with mental health issues don't commit dangerous crimes. But I think there's this impression amongst us that that's not the case. And so it causes us to be afraid of, oh, this person has schizophrenia or whatever, so we're not going to put them in the community. So I think education is really important around that. And making sure there's services, and then making sure the judges understand that there's some type of monitoring going on. So with AOT, one of the keys is making sure that case management's going on, so that there is continuous monitoring, that if the individual begins to decompensate, if they're not going to treatment, that there's immediate response to that. So, there can, under AOT, if they start, some of these things start happening, they can be immediately picked up and brought in where the judge can deal with that issue. So I think with all of those things in place, I think it would reduce the judge's resistance. Obviously, it's going to take some time and education, and some, maybe being able to show them proof that it's effective. We know it's working in certain jurisdictions across the country, but I think those are some things that I would think that would be important to dealing with that issue. Peter.
Thank you. Thank you to COSCA and Nicole for taking the leadership on this issue. We're concerned in Chicago a lot about this. We have 9,000, now it's down to 6,000 people in Cook County Jail, and many have mental health issues. But one thing we've learned, and I'm still trying to figure this out as someone who's been dealing with this, is we really need to differentiate between the kind of mental illness that we're talking about. So we used to think that when they closed the hospitals, those people moved over to our prisons. And mainly they were talking in those days about schizophrenia, major depression, and major bipolar. So I asked the clinical director in Chicago, has the percentage of people in the population who have these major disorders, has that increased? And the answer I get is it has not. So the question is, well, how do we have so many people with the diagnosis of mental illness if that's the case? And I think what we're finding is that a couple things happened. One was drugs, the introduction and use of drugs. And the second is the Medicaid definitions for mental illness have increased greatly. So if you look at the numbers of people who have been determined mentally ill by Medicaid, they've gone up really drastically. The reason this is important is it's about treatment, so that you're providing the right treatment to people with a certain problem. You don't want to give cognitive therapies to someone who's schizophrenic or in a major depression or even major bipolar. You want to use medication, talk, relationship support, whatever. And lastly, I'll just give you the name of a guy that's written about this. I don't know if you know Matt Epperson from University of Chicago. And he talks about first order treatment in mental health and second order. And the first order was what we were talking about. But the second order treatment is more about what he'd call criminogenic issues that have to be addressed. Cognitive therapies and this sort of thing. So I won't go on anymore except to say it's a pretty complex issue that we need to understand even better. I don't know, Nicole, does this make sense in terms of what you've looked at?
I think one of the things that Peter points out, which is key, is also goes back to training and education, both of us and of our judges. Because if you think about it, a lot of times, just it's natural, a lot of times our judges over-order treatment because they're trying to deal with the issue of, I'm worried about what's going to happen if, and so I'm just going to order everything. And it's not just mental health related. It can be drug or alcohol. It could just be probation terms. It's just sort of, that's just sort of a natural tendency. And many of you in this room and many of us have worked, many judges have worked, and probation staff in particular have worked on trying to tailor, once again, what is appropriate for this individual. So, you think about the need for judges to have training on what types of services are appropriate when certain things have been found to be issues, or maybe even more importantly, the need to have close connections with someone who either is on staff at the court or works with the court about what are appropriate treatment for these individuals. The thing that has worked really well in problem-solving courts is that judges rely on staff or treatment providers who give them recommendations about what will work or what won't work with this individual. And I find that many times that's not the same thing when it comes to either criminal justice treatment of mental health issues or even in the commitment side of things. So, making sure that those things are in place is really important, because when you start talking to judges about first order, second order, don't do cognitive behavior therapy, some of them are just going to glaze over and say, what in the world are you talking about? And they have so much to remember anyway. Trying to sort of sort that out on an individual basis is a difficult thing. So maybe thinking about what types of resources we could provide the judges in that area is really important. Yeah. One second. Let me get you the mic back. Hang on one second, Peter. I just want to make sure the people that are watching remotely can hear you. If I can figure out how to turn this on. There we go.
So every day in Chicago, in the presiding judge's courtroom of our criminal courthouse, we have an unfit misdemeanor call. It's a felony courthouse, but we're handling unfit misdemeanor cases. Those are the individuals that come closest to that first definition. People with schizophrenia, major disorders, and they're getting picked up because they're urinating on the grass or hallucinating, and has nothing to do with criminogenic behavior. It has to do with serious mental illness. That's where we need to find, we're struggling with this, trying to find a way to avoid bringing these people into the courthouse. So again, it just goes back to our understanding as a collective, the complexity of this mental illness issue.
Right. Over here.
Thank you for your presentation. I had a question about case management because people with mental health illness present a unique problem, I think, for case management because they have more barriers to managing their own health care, unlike other people.
Right.
So, for people in the justice system and outside the justice system, case management can be a problem. And so what are some mechanisms courts have used to help with case management, in particular in rural areas where some of the resources aren't as common?
Very interesting you bring that up. Speaking specifically about rural, the COSCA policy paper for this year that we're working on is Justice in Rural America. We recognize this is a huge issue, and it sort of came up when we were talking about the mental health issues about how do we provide services, whether it's case management services, psychiatric services, name whatever service in rural America. It's hard to do that because there just aren't the services. And we can't allow the fact that you live in rural America to be a barrier to everything that if you lived in an urban area, all of a sudden you get. And the opioid crisis is a perfect example of this because most of the opioid crisis is in rural America. So your question is really on point. And so I would just urge you all that in December when we release our rural justice paper to take a look at that. And there'll be a session on it next year at this conference. But I think a couple of things, at least from my perspective, and I would invite all of you in the room to help with this. One is really thinking about the idea of, once again, this idea of community mapping. What resources are there available in different areas of the country, especially in rural areas? So, bus services is one that just comes to mind right off the bat. That transportation is a huge issue for individuals who are the ones we're talking about here. Many people with mental health issues don't have good transportation, don't have good housing. So I think thinking about what are the services that are available in the community and where are the holes and how can you begin to address those will really help with case management, because those are, I think, key barriers that keep that from happening. So if you think about it, you say, well, when you leave here, I'm going to go back to Harris County just because it's so huge. If someone gets released from jail and they say, you've got to go to this appointment today and this appointment tomorrow and that appointment on Thursday, and by the way, they live on one side of Harris County and the services are somewhere else, and there is not good transportation unless you're going downtown to Houston, how do we expect people to be able to be successful? I mean, I think we've got to think about where do we provide services, how do we provide them? Thinking about, do we need to place these services in the community with individuals where it's more appropriate? So even I saw someone a couple of days ago using GIS mapping to think about where's healthcare available, where's transportation available, and begin to looking at sort of on a map where we can see, oh my gosh, there's this area right here where we have a lot of individuals coming from where there's nothing. And beginning to have these conversations as a convener, having these conversations with community leaders and service providers about how do we get those services. I don't know if that really answers your question directly, but those are some of the things that I think are key to case management, because as you say, we can case manage all we want. If they don't have the ability to get the services or get where they're supposed to be, then there's not a lot of case management going on in those cases. I think we may have time for one more question or comment.
It's a question. Basically, since we're in the world of healthcare, talking about mental health, cultural competency comes into play. Right. And so I'm kind of interested if perhaps you could discuss what considerations might be relevant when we're talking about maybe people with limited English proficiency or different ethnic groups that might be carrying a systematic abuse over many years or something like that their mental health issues have been studied and shown to be different, or their attitudes toward mental health may be significantly different.
I'm not sure you're going to like my answer because I'm certainly not an expert in cultural competency. I'm aware of the issues that you raise, and they're very important. I think the answer I would give is that we should be aware of those and we should take them into account. And so, a lot of times, we need to be thinking about who are the people that we're dealing with. And a lot of times, I think we think about it from our perspective. Oh, we'll provide this service and that service, and yeah, maybe they're great services for people who are like you and me, and we don't think about those individuals and the issues that they may have. So thinking about limited English proficiency, are we providing enough services for those individuals? Once again, having that conversation about who are the people that we need to serve and what are their needs. And I would just encourage you, and this is kind of one of those issues where we can sit in our courthouses, or what some people might call our ivory towers, and plan all we want, and we might not plan appropriately. So making sure to involve community leaders who are dealing with these issues regularly in those conversations is vitally important to making sure that we address the issues that you raise, because you or I may not be the experts in that, of knowing how to deliver them in a way that's effective and culturally competent. But if we bring in the community leaders who are dealing with those issues on a regular basis, or community service providers that are dealing with them, then maybe we can do a better job of building that. Thank you all so much for coming today. Hopefully you've gained a little bit, and we look forward to hearing about exciting things going on in all your communities. Thank you very much.